The Supreme Court also recommended to set up civil service tribunals both for the state and central civil servants. Again, in 1975, it was recommended for setting up of service tribunals by Swaran Singh Committee. The idea of establishing service tribunals to save the courts from an avalanche of writ petitions and appeals, also found in the decision given by the Supreme Court of India in KK Dutta Union of India, 1980. Background facts. In 1976, Parliament passed the Constitution, 42nd Amendment Act, 1976, by which it added a new part in the Constitution ID, Part 40A, entitled as Tribunals. This part contains Article 323A, giver powers to the Parliament to provide the establishment of tribunals only for public service matters of the centre, states, public cooperation, local bodies, and other public authorities. Under this article, the tribunals can only be established by the Parliament. In simple words, the Parliament has provided with the powers to adjudicate the disputes related to public service matters from all types of courts and place it before the administrative tribunals. After the amendment, the Parliament passed the Administrative Tribunal Act 1985 in pursuance with Article 323A. It allowed the Centre to establish one central administrative tribunal, state administrative tribunals, and joint administrative tribunal, a joint tribunal for two or more states, for rapid, effective, and just justice to the aggrieved public authorities. Under this article, there is no question of the hierarchy of tribunals. Article 323b allowed both the Parliament and the state legislature to provide for the establishment of tribunals for the disputes relating to the following: industrial and labor disputes, taxation, land reforms, foreign exchange, election to Parliament and state legislature, import and export, rent and tenancy rights, the ceiling on urban property, and foodstuffs. Under this article, a hierarchy of tribunals may be created by the state legislature and the Parliament, many writ petitions, special leave petitions, and civil appeals. The separate decisions by the High Court and several provision in different acts and legislations all pertaining to the constitutional validity of Article 323A2D, Article 323B3D, the Administrative Tribunal Act 1985, and the tribunals constituted under Part 14A of the Indian Constitution can be effective and efficient substituted for the courts in discharging the power of judicial review were grouped together in this case. Main issues: 1. Whether the tribunals constituted and functioning under the Act can be said to be effective substitutes for the High Courts in discharging the power of judicial review. If not, then what are the amendments required to make the tribunals conform to their founding objectives? Whether the power conferred by 3D of Article 323b or by 2D of Article 323a upon state legislatures or Parliament exclude the jurisdiction of all courts, except Supreme Court under Article 136, in respect of complaints and disputes referred in Clause 1 of Article 323a, and runs counter to the power of judicial review conferred under Article 226, 227, and Article 32 on High Courts and Supreme Court respectively. Whether the tribunals possess the competence to test the constitutional validity of a statutory rule, which are constituted under Article 323a, or under Article 323b of the Indian Constitution. Arguments. The argument from the side of the petitioner are as follows. They argued about the constitutionality of the tribunals created under the Act and the provisions such as Article 323a2d and Article 324b3d under the Constitution of India, the exclusive power provided to the tribunals to exercise the jurisdiction vested in Articles 226 and 227 for the High Courts, and the power to interpret the provisions of the Constitution on which only constitutional courts have sole right are susceptible, as these rights cannot be bestowed to the quasi-judicial bodies on which executive have its influences. Articles 323a and 324b under Part 14(a) of the Indian Constitution allow the Parliament to effect the sacrosanct jurisdiction of the Supreme Court as per given in Article 32 of the Constitution, and therefore liable to be struck down. It was argued that the impugned provisions are unconstitutional, as they exclude the jurisdiction of the High Courts under Article 226 of the Constitution and the Supreme Court under Articles 32 of the Constitution. This is for the reason that Parliament cannot, in the exercise of its constituent power, confer power on the state legislatures and itself to exclude the constitutional jurisdiction conferred on the high courts, Article 226 of the Constitution, and the Supreme Court, Article 32 of the Constitution. As the power to amend the Constitution can be conferred on the legislatures neither state nor central, and 2. The provisions under the Act also violate the basic structure of the